Here, I think it's quite a simple chapter. Okay. Okay, beginning from this slide, things start to get more important. Okay, more important in the sense that how you should push your question. You must think first. You don't bother lah. You don't bother whether it is a similar fact evidence, opinion evidence, or whatsoever, because anything they ask shall be normally inside section 5 to 55. Okay, so whenever things that the topics the question being drafted required you to give input about relevance, okay, you must go through this three procedure. Okay, first you must ask your good self, what is this evidence about? Is it about a facts in issue, or is it a relevant fact? I repeat myself, what is this evidence about? Okay, what is it lah? Whether is it facts in issue or relevant fact? If it is so, either one of it is satisfying the elements of relevancy. Okay, it is relevant piece of evidence. Once it is relevant, then you can proceed to the next step to talk about how should this evidence be brought to the court. What kind of mode of evidence? Should I bring a original paper, or should I bring a secondary evidence in the event I could not produce the primary one? Should I just call the witness to come to the court, or how? Okay, the admissibility of the evidence eventually get the thing very strict, and must understand this. Okay, the admissibility of the evidence itself is a question of law, you know. Okay, that means to say it is decided by court, by the judge, not by you. Okay, so this is how. After the evidence had been admitted by the court, usually in the trial, we mark the evidence as exhibit. Subsequently, the judge will give judicial consideration or appreciation. They will evaluate, okay, the evidence, whether how much value to be put on that particular evidence itself. Okay, I give you an example of my murder case again. Okay, I was being charged to murder my wife on what date is this today? Okay, 10th of January, early in the morning, around 10 o'clock, by stabbing a knife into my wife's chest. My wife died because of hemorrhage, lost a lot of blood. Okay, so this is the case. Okay, I was charged by prosecution for murder. So now I give you one thing. How do we evaluate the relevancy? So now you have a lot of evidence, ma. The police found CCTV. The police found a knife. The police found blood-stained clothes, okay, in the house that I stay with together with my wife. Okay, now we take example. The knife you want to admit because you are a DPP. So you must ask yourself, is it relevant? Definitely is relevant because it is a murder weapon. What? Okay, so it's satisfying. What? Okay, what is it? Okay, and then how should it be admitted? You have two choices, either to take a photo of that particular knife, or to show to the court this is the knife, and if you want to be a bit dramatic, better you don't wash it, blood stain. Wow, the court will be more convincing. Okay, eventually the court will, oh, this piece of knife is the knife that used to stab my wife. So the court will admit it, under section 136 and mark as exhibit. So if the court is seriously convinced that that knife, after testing the DNA, my fingerprint and all that corroborative evidence, wow, this knife is indeed the murder weapon. So it carry a lot of weight. Okay, you get the flow. So this is how you should also do when you try to learn evidence act. Otherwise, a bit difficult without such uh, imagination. Okay, and we have a distinction between legal relevancy and logical relevancy. Legal relevancy is codified, is provided inside your Evidence Act 1950, ranging from your Section 5 up to your Section 55 Evidence Act. Okay, so this one confirm, if it is fall under it, confirm can be admitted because it is determined by the legal rules, okay? And also some certain standard and requirement must be fulfilled. Whereby logical relevancy is more on a law theory. That means to say common sense, you think this should be admitted, how come? But it doesn't comply. Let's say, for example, the dying declaration. By right, my wife, take for example, my wife again, pity her tonight, right? Before she died, she talked to the ambulance officer. Chi, what short sentence, Chi, dot, kill, finish, by right. Okay, this is a dying declaration. But unfortunately, there's a lapse of time, some issue there. Maybe there's the noise with the ambulance, somehow or rather it cannot be admitted in the court, all right, even though it is logic for such piece of evidence to be admitted. Okay, what I'm trying to say is there are certain criteria for you to get the status of legal relevancy, because once you admit it under the sections provided under Evidence Act, the evidence itself should be admitted, by right. Otherwise, it's a question of law, appealable issue. So I hope you do understand what I'm trying to say. And before you understand what is relevant, it is good for you to understand a few terms first, okay? You must go to your section 5 in a very, I think it's not just very, super detailed manner, whereby your section 5 already told you the first of your Evidence Act, part 1, relevancy. Okay, evidence can only be given in any suit, that means to say civil and criminal whatsoever. Okay, regarding to existence or non-existent. Existent means DPP lah. Want to show that the murder indeed took place lah. The defense will definitely, the accused me lah, will definitely will show non-existent of this fact. So fact in issue. The keyword here is fact in issue. How do I mark this? Wait. Okay. Facts in issue and other facts. The proper words here, if you want to make it simple, is relevant facts, but it is by right, we must follow the statute lah. All right. So this is so-called other facts declared to be relevant. That means to say whatever evidence you put forward in your criminal or civil trial shall only confine to facts in issue and or all, okay? Other facts declared to be relevant, okay? And how do we know whether a fact is relevant or not? You can cross-refer back to the definition in your Evidence Act. It say inside your, this is a very small word, in your Section 3 Evidence Act, relevant means one fact is said to be relevant to another when it is so connected. That means to say other hubung kait, other kaitan lah. You don't talk about my grandmother in my murder case. You talk about the knife. You talk about, for example, I'm having a sour relationship with my wife. That is relevant, connected, You see or not? Why I committed murder. So you cannot just talk about my grandmother who is now in Penang. Nothing to do with this case. So get the issue straight. Facts in issue or other facts to declare to be relevant. Okay. Whenever I unconsciously repeat myself, that means this is very important. Okay. Right. Oh, wait. Okay. All right. So I just told you, facts, we have a physical and also psychological. Okay. So that's why you have factual witness and also expert witness. Okay. Mm. Five sense, the physical, five sense, okay, hearing, seeing, smelling, etc. And also mental condition, what you think, okay? So not all facts are relevant. Okay, you can, semua benda adalah fakta, because whatever you tell, if you want to know lah, what is the question of facts? If your answer are facts, okay, then this is a question of facts. What is the question of law? If your answer to it is a law, that means it's a question of law. So what actually is fact is whatever thing that you are talking, usually 5W1H law, what is your name? And you give your name. My name is Chi. This is a fact. What is your age? My age, how old are you? Sorry, how old are you? Okay, so I'm now 40, for example. So these are all facts, but not all the facts are relevant and should be going to the top. Okay, this is very important. So what actually, because I said to you, facts are deemed to be relevant and satisfy the Section 5 provision only two, facts in issue and other facts declared to be relevant, isn't it? So facts in issue usually is the disputed fact. Like I have said to you, you want to get a judgment in the court at the end of the day. Civil case, either you win or lose. Okay, VPP, whether you are guilty or not guilty. Okay. Certainly, you cannot agree on something. That's why you go to court. If you have pleaded guilty, all that actually evidence will not be even be tender. As far as you know, I mean, if you pleaded guilty earlier, there will be no trial. So evidence no need to submit, what, isn't it? So there's no application of Evidence Act here. So similarly, civil case also, certainly you cannot negotiate and achieve a consensus, isn't it? I said Gun had breached the contract, so I demand Gun to pay me instantaneously. Okay, because Gun refused to accept this fact that he breached the contract, and then he refused to pay me. This thing go to the court. So there's actually dispute. So fact in issue is actually, in a simple term, disputed fact. Okay. So fact in issue, I give you another example lah. Okay. Here, the example that I try to imagine is A claim B took his BMW without any lawful authorization, and B indeed took his car. Okay, try to digest this information. But B claimed that he had actually paid 50,000 to A. So B alleged that he is the rightful owner of the BMW. When we look at actually everything is the fact, okay? But then the fact that should not be relevant here is the fact B had taken A's BMW, okay? Because both parties agree already. You see or not? And the condition of the BMW, whether this BMW or manufactured in year 2020, or the interior is a BMW X3, okay, all that no dispute one. So it is not facts in issue unless it is raised. Okay, what I'm trying to make things simple for you is the fact in issue here is A alleged no lawful authorization. So evidence need to come from here. Why you say B has no authority to take your car? And instead, B must also bring some evidence to the court that he had paid this 50,000 to the court. He had, B and A had signed the agreement of transfer. Oh, the JPJ registration, the transfer, the thumbprint had been done, all that. So these are how evidence shall be relevant, okay, pertaining to the fact in issue. Okay, if you really cannot digest what I've said, if they ever come up with fact in issue, isn't it? How do you define? Just copy lah. Just copy from your section 3. Okay, the interpretation is already there. Okay, and okay, take for example the case of Tan Tu Ya, PP against Azila Hadri. Okay, the defense counsel. Okay, not the what we call the defense counsel had opposed to the admission, I mean the admissibility of the evidence of there is some deletion of immigration entry of Tantuya and her sister to Malaysia and China. So they are trying to link the Atatuya case is closely related to some political power. You know what I'm trying to say? So, but however, this is a trial of a murder matter. So, is immigration entry has anything relevant to do with the murder case? Because the facts in issue is murder, whether Atantuya died or not. Okay, whether the accused had really action actors rest that means kill Atantuya by bomb or not. Okay, and whether have the mens rea intention to cause her to death or not. These are the by right should be the facts in issue. Okay, so it is not. It is held that this is not fact in issue. Okay, so again, you have some other definition from Rupert Cross saying that in civil case or I mean plaintiff in civil action or prosecutor in criminal proceeding must prove lah. Okay, usually it's the elements lah, the elements of a crime or the ingredients of a thought or the criteria for contract. Okay, take for example, breach of contract. You must firstly show there's a valid and legally binding contract, and then you must show that it is a breach of the term of the contract, and then subsequently, and you must show that you suffer loss as a result of that breach. So these are the elements. It becomes fact in issue in civil case, whereas in criminal proceeding, the actus rea, mens rea usually confirm substantive law elements confirm will become facts in issue. Okay, give you an example. If let's say I murder my wife, like actus rea, mens rea is them. Confirm the prosecution are going to say that CCTV show I stabbed my wife. Okay, there's a knife there, all that. I have intention because I stabbed her in the heart. By having medical knowledge, I have intention to kill her because it could not be just I stabbed her in the chest, in the heart. So surely will die one. Okay, so these are the elements. I would definitely say, oh no. Okay, so something like that. Okay, those are the facts the defendant must rely to establish a defense. I will say this is provocation lah. I will say, you see, I got here. Actually, I was beaten by my wife, and then it was a self-defense. Or I will show you actually, oh, now I have a schizophrenia. I'm having insanity. I show you my pills and etc. Okay, so these are to rebut, to counter the charge or your civil allegation, I would say. Okay, and okay, we look at the specific proviso. Section 5 is just a general one. Section 5 is just a general one. Evidence not relevant should not be admitted in the court. And even let's say, for example, the evidence itself, if it is not relevant, it should not be admitted by the court, even the opposing counsel, for whatsoever reason, fail to oppose or fail to object. Adversarial party, you must always remember, judicial proceeding is not one man show, one prosecution say all the time. It is present together the defense counsels. Okay, so defense counsel sometimes look at it, listen to the story is not right. You must stand up and objection, raise objection. You think this is not relevant at all. Let's say, for example, the parties did not do so. The defense counsel were not paying attention, playing handphone lah. I mean, too much already. The trial dragged too long, tired, play handphone. Suddenly miss one evidence that by right is not relevant and should not be admissible. Even though he did not post, the judge will use his discretion under section 136, will say, no, this is not something relevant. Okay? This is how it means. So please bear in mind the first criteria to fulfill is the evidence must bear some relevance, must be relevant one. That means facts in issue or facts declared to be relevant. Otherwise, there will be no two or step three. Okay. Okay. At the end of the day, you don't look at the trial itself. You look at the particular evidence, like the one that I have brought to your attention, which is the knife. At the end of the day, how is this knife going to influence? What is the ultimate outcome of the evidence itself? Eventually, there is no, the court will not put a word like the knife is true, the knife is false, it's not a genuine one, it's not the real one, something like that. The court will only give three comments to this evidence: whether the prosecution had successfully proved the knife to be the murder weapon, and the court is convinced that it is memang existent, and it is highly probable that this knife is being used by Chi to kill his wife. Okay, this is one. Okay, second outcome, second possibility is disproof. Okay, the knife, I cannot believe this is a knife that used as a murder weapon, and the prosecution had failed to prove this knife because the knife has no fingerprint, and then the blood stain found was not the one my wife is having. It's the other one. Actually, I use it to kill a chicken. It's actually a chicken's blood, take for example. So the evidence is disproof. Okay. And the third possible conclusion that could be reached by the court would be not proof. Not proof means the court is not sure whether the knife is not is that means to say the weight is somehow is nearly zero already. That means to say the court is neither this thing had been buktikan ataupun tidak dibuktikan. Not sure. Okay, this is called not proof. Neither proof or nor disproof. These are the three outcome of your evidence. Okay, why this one is quite important? Because eventually, this is how the evidence is being processed lah. And as you know, the trial is not just based on one single evidence. It's a cumulative of the evidence as a whole, So you need to know lah, roughly. Okay. So these are what I have said. Okay, declare relevant and facts in issue. Okay. So why I use declare relevance is because somehow or rather collateral facts, for example, the precondition. I use one example. If you use section 32(1)(b), documents supposedly used in ordinary course of business, take for example. If you want to rely on section 32(1)(b), by right, you have to satisfy the precondition of your section 32(1), That is whether the maker of that document is dead, okay? Or if it is alive, you have to satisfy to the court that you have exhausted, you have called so many times for this maker to come to the court, but he refused to come. He cannot be found at all. Call tak angkat, email tak angkat, and then serve the documents, subpoena to him also, don't want to come. And then the expenses for us to call and wait for this, what we call this particular maker of that document to come to the court is so much, so high. Probably he's in USA, the air ticket, the claim itself is just about 50,000. The air ticket for him to come is 60,000. So worth it, isn't it? So these facts are actually is not connected to breach contract that I and Gun had. For example, if I need this sort of I want to use documents in the ordinary course of business. That means I'm relying on section 32(1)(b). But this USA thing, the what we call the witness could not be found by right, it's not the facts in issue, isn't it? The facts in issue whether got breach of contract or not. So this is not even relevant facts because cannot fulfill under your section 6 until 55 lah. Okay. But these are the so-called collateral facts that you need to bring to the attention. So these are called precondition. These are something extra lah, that you need to prove to the court before you can rely on your section 32(1), the subsections that I've said to you, as well as the credibility of the witness, okay? And somehow or other you feel that this witness being bribed, and then you feel that he's not maybe not hostile, but unfavorable witness. Somehow or other, you cannot show that this witness is a mole, is a tahi lalat, he ruin your case, what? Because you are prosecution. Take for example, you cannot tender evidence that, oh, this I saw this witness just now gave being bribed by the Hughes family. Ada ang pao lah, get ang pao. This sort of evidence by right, no relevancy at all to the murder case. But somehow or other, to impeach the credibility of witness, collateral facts shall be declared as relevant. Okay? This is how you admit it lah. So section 136, court had absolute discretion. So depends on how they interpret and how they see this piece of evidence. So the good case here that I think you must memorize for your whole life would be PP against Datuk Sri Anwar Ibrahim number 3, 1999. So our Tan Sri Augustine Paul, very famous judge, he has said this: question of admissibility of evidence are question of law and are deemed by the judge. That means judge had absolute discretion. If it is the duty of the judge to admit all relevant evidence, it is not less his duty to exclude all irrelevant evidence. Okay, if you can memorize it, you can memorize. If you don't, you just put court had absolute discretion, okay, to decide on the admissibility of evidence. And the admissibility of evidence, as I had said to you, except for the content of the documents, all the other facts must be proved by oral evidence, okay? So oral evidence, the witness need to come to court lah, and governed by your section 137 and 138. Every witness must undergo examination in chief, okay, by the party that call him, and cross-examination by the opposing party, and then finally end with re-examination by the party, by the counsel that call him, to repair any errors he made during the cross-examination. So this is how it works. And all facts need to be proved. I think I said it to you already, except in the event that the court took judicial notice. Okay, and facts admitted lah. Okay, admit facts. Okay, there are several issues here. Failure to object irrelevant evidence, like the example I put forward to you. The opposing counsel is playing handphone during the trial, never pay attention to the trial procedure at all. So even if you fail to object irrelevant fact, it is still not admissible. That means to say the evidence itself should be thrown out by the court. Okay. But whereas failure to object mode of proof, mode of proof, the method you bring the evidence to the court. For example, instead of primary document, I bring a photostat document. This is definitely not primary evidence, primary documents, isn't it? But the opposing counsel is playing handphone, never object, and it is being marked as exhibit. So this evidence can go through, okay, provided it is a relevant one. Okay, so first step must be relevant. Then the court is not so particular about the mode of proof unless the other party object. Okay, unless the other party object. Okay, this is how I want you to understand in depth. Take for example, in civil trial we have bundles of documents. Okay, some is marked in bagian A, bundle A lah. That means all people agree with the content, and A is the happy one lah. No need to go for trial. I mean to say no dispute. Okay, B is the one that content is dispute, but the authenticity of the document is not dispute. That means to say the maker shall be exempted to attend the court to save cost and time. Okay, the bargain C is the one worried. So whenever things being marked as document C, the party that wanted to rely these documents must call the maker. Otherwise, it will be a documentary hearsay. Documentary hearsay is not admissible. Okay? For example, if you want to use section 32(1)(b), for example, or you want to use section 73(a), you must produce supportive evidence to support why you are able to satisfy the precondition. Okay, take for example, if you want to use the computer generated what we call document section 90(a), okay, admit this document without calling the maker, then probably you have to give certificate. This is one of the method lah. So the other party cannot object. Okay, let's say for example in the scenario whereby you did not call maker to come and no certificate is tendered, the opposing counsel did not object. Okay, and then the court marked already as exhibit plaintiff satu. Then this piece of evidence shall be admitted by court. Okay, so the mode of proof is not objected. Okay, very important. Similarly, now you have section 73AA. The prosecution shall request the court before the trial. Usually, the drugs case, take for example, all the evidence, the photo, everything will mark. Okay, PW one or the exhibit they will mark as exhibit based on whatever serial number they want to give P1, 2, 3, 4, 5 to 10, take for example. Okay, so if the evidence is marked as exhibit and the defense counsel did not object, also it will deem to be admitted. Okay, so that's why during the trial you must stay alert. Okay, and apart from that, there's also issue about the best evidence rule. Okay, I want you to just think, but I should not use the name Chi. Okay, I use the word gun better. All right, crime scene. Okay, so back to the same story that I killed my wife. Okay, Chi killed his wife. Okay, in the room. And then now we have three evidences. Number one, Gunn witnessed the whole incident and he was just 10 meters away from crime scene. Second, one old man standing about 300 meters away from the crime scene, but somehow rather he witnessed the crime took place, but his eyesight, as due to aging, is very poor. And then the third one young lady hears a scream from the opposite street, but did not see anything. So, if you are following the theory of the best evidence rule here, by right, by right, you should have called Gun as your number one witness priority because he can give direct evidence. He saw me stabbing my wife with the knife and he got a clear eyesight. He's just 10 meters. He can tell every single detail of the evidence. Okay. So, this correction because I changed to gun. Okay. So by right, gun is the best evidence for your case. Can get what I mean? Not old man, not the young lady. Okay. So the strict approach, the debatable issue about this strict, what we call the best evidence rule will be, let's say Gun refused to cooperate. He refused to come to court. He refused whatever lah. Whenever trial, he tried to run overseas, etc. Can we call the old man? Can we call the young lady? If you are following the strict approach, according to this case, omission against Becker, by right, cannot. Okay. You should give the court the best evidence. Okay. If it is not the best evidence, the court will be reluctant to accept it because you have better one. Why you don't want to bring him? I mean, this is the strict approach. But now, like I said, the case itself cannot be hanged forever. There is a time constraint and also practical and realistic requirement. The court also need to close its case. Okay. So even if, let's say, Gun refused to come, second and third best evidence nowadays in Malaysian court practice can still come, okay, to give circumstantial evidence lah. This is what it meant, okay. So according to the case of R against Onyu Fragzik, I suppose Russian, the body of the deceased is never found. By right, to prove a murder case, you have to prove that the person is dead, correct or not? So the dead body or the corpse must be able to be produced. This is post-mortem report and also photo of the dead body lah. Okay, shall be tender. But somehow or other, this case, the body of the deceased was not found, but the court accepts circumstantial evidence. That means to say the family could not find him. I find that I mean the person for such a long time, and then trace everywhere the place that the victim commonly go also cannot find. So this is how the court established this sort of circumstantial evidence to show that person is dead. All right. So second best evidence is allowed. Okay. But we have some issue here lah. Since the best evidence is not being produced, the weight of the so-called second best evidence is certainly reduced. That goes without saying, okay? And having said so, even if you, because this is just a general theory, you cannot rely that the best evidence rule had been relaxed nowadays. So even though I do not produce the original document, court will automatically accept my photostat contract. It's not like that. Certainly, some precondition still must be fulfilled. Okay. And the weight of the evidence is entirely at the discretion of the judge. Okay, so it is a form of judicial appreciation, how they assess, okay, either by the quality of the evidence itself. Let's say, for example, if CCTV recording to show that the murder of me and my wife took place, whether this is a 720 pixels and also 1040 HD one. There's a distinction, isn't it? So the quality of the evidence matter, the credibility of the a witness also matter. Suddenly, there's an issue of bribe of the witness. How to believe? You see not? Even though somehow or other his statement is relevant, but the weight I reduce lah. Okay, and also mode of proof, etc. Factors for the court to give consideration. Okay. So we go to specific what we call proviso of Section 6. Okay. Section 6 Evidence Act, I think also you need to study well how it works. Okay. Section 6 is a hearsay exception. At the same time, it is talking about um the contemporaneity of an action, you know. That means to say, benda yang berlaku pada satu waktu ketika. That means at the same time, same place, same transaction. It happens instantaneously. Why is it so? Very important, because whenever the statement or the act that come out from the, let's say, for example, the victim, for example, my wife, again, my wife, if let's say the sister was in the next room where the murder took place. So before she died, she said that she killed me. So this statement can be admitted under Section 6 because there's no time for my wife to rethink, to fabricate, to concoct, to falsify, okay, to evaluate what is the consequence to say this statement. It just come out from her mouth. So this thing happened in a very short instant of time, okay? So must try to understand it. And this Section 6 apply to act, conduct lah, that means perbuatan, and also statement. Statement means whatever you have come out from your mouth lah. Okay, very important. Even pointing finger is a act. And she killed me, one oral statement is a statement lah. Okay, so this is Section 6. Please remember the important feature. Okay, same transaction, same time and place. Okay, very, very important. Always come out. Okay, and it is a codification of res gestae rule. Okay, and Section 7, it talks about your occasion, cause, or effect of facts in issue. Take, for example, the murder case. What is the facts in issue? The actor's race and mens rea confirmed. So what is relevant here under Section 7? So what is the opportunity that cause Chi can use a knife to stab his wife's chest? It must be they are in the same room lah. That's why the act could be committed. So what is the effect? There are some blood stain found in the room. So there's what we call the knife is there, and then some marks over the body can be seen. So these are the effect. Okay, so try to understand this. And your Section 8. Section 8 usually talk about your motive, why you have done so. What is the motive? Probably I have an affair, for example, or I have a quarrel with my wife, you know, long duration of disgruntled arguments, all that. Okay, so these are the motive, okay, that could be admitted to the court. So what are the preparation that I have done? Buying a knife in Mr. DIY, like for example. So and also previous or subsequent conduct. Okay, try to understand it. Previous what I have done in order to do this act of murder. Take for example, I purposely invite my wife. In fact, we separate room already, ma. I invite her to come to the room. I said I got something important to discuss to her. These are the application of Section 8. Okay, very important for you to know all this, and you have to apply, And Section 9, Evidence Act, very wide provision. It used to explain or introduce fact in issue or relevant fact. That means virtually everything you can under Section 9. And somehow or other, it is commonly used to identify the party, okay? The party, and also the time, all that, the relationship, some more, okay? Section 9. So right? And okay, I want you to understand this illustration C of your section 9. Okay, because section 9 is used to introduce fact in issue or relevant fact. You see the illustration given here. So A is accused of crime. And then soon after the commission of the crime, A fled from his house. So the important part here, the statement here would be A fled from his house, which is Section 8, Evidence Act, which signifies subsequent conduct because A did a wrongful thing. So naturally, he will try to escape from being caught by police, correct or not? So this run from home statement could be emitted under Section 8. But then the reason that the defense would like to raise, he had sudden and business in Johor Bahru. Is it really relevant? No what. But somehow or rather, Section 9 said it is relevant to explain why A fled from his home. It's actually, I did not do the crime. It's just that I'm not escaping. I got business in Johor Bahru. So this introduced Section 8. Okay, so you get the meaning. That's why Section 9 is a very wide provision. Okay, and then you have your Section 10. Section 10 is very easy to understand. It talks about your conspiration, common intention. It could be criminal or civil. Okay, that means one person, two person must be two person lah. They collude, pakat lah, collude to defraud a person or they somehow plan to rob a bank. These are admissible under Section 10. Okay, and you have your Section 11, A and B. A is usually used in alibi evidence if they are inconsistent with any fact in issue or uh, relevant fact, okay? But usual application in CLP examination would be alibi case, okay? You use section 11A, okay? And also you can rely on your illustration A, okay? Because alibi itself is a very powerful defense. Let's say, for example, prosecution witness, the PP charge me for murder. If I raise the defense alibi, said that, in fact, I was not in Johor on the day, on the time that the murder took place. The prosecution cannot charge me, if I can raise, I can call witness, take for example, my master, Miss Christie, and also one of my friend, Mr. Gan, was actually together with me that time, and we were in KL. So this come under Section 11A of Evidence Act. And if it is being established, then I can escape free lah without being held guilty. Okay. And the case you can use is Dato Mokhtar Hashim. Okay, this is a very common case. In fact, to pass your CLP, it is a common misunderstanding that you must memorize a lot of case. Not really. The application of statute come first. Okay, use the right proviso before you go and regurgitate the case law, because they don't want to see principle. They want to see which section you have rightly applied. Okay, and section 11B, 14, and 15 are so-called similar facts evidence and shall be covered later lah. And section 12 show damages. Okay, that means to say apa kerugian, apa what we call your loss, what is the degree of injury. Okay, like for example, if you have a negligence claim, if it is negligence, okay, what are the damages that suffered by the plaintiff? Any bills, loss of earning, any income that you can bring as a piece of evidence. This all will come as under section 12. Okay, your loss of motorbike, your nursing care, your medical bills, and all the invoices um, because of the cautious action, okay, of the defendant, you can bring under section 12. This is how you apply it lah. And section 13, just ignore it. It is talking about the right of custom. 16 also, I don't think I have ever seen it. Okay. But now I plan to use our remaining time to do one question with you. This is the latest 2023 supplementary paper. And then we can end our lecture. Okay. I will read this question. Daniel is charged with the murder of his wife, Betty, by pushing her to death from 39th floor of their penthouse balcony at Skyfall condominium. Okay. Daniel maintains that Betty had committed suicide or had accidentally fallen off the balcony. So Daniel and Betty inhabited the penthouse of the luxurious Skyfall condominium with two living mates, Ella and Dolly. Unhappy with the marriage, Daniel began to have an affair with his secretary, Linda. So Betty's confrontation with Daniel regarding the affair were met with Daniel's denial. Of course, denial. So they fight. On 13 January 2023, around 11:30 p.m., neighbors heard loud noises, and a lady scream originating from the penthouse, culminating in a resounding thud, which was Betty's fatal fall from the penthouse balcony. Heard a boom. The body must have fallen from the balcony and created this loud voice. Okay. And Daniel explained to the authorities that he had granted the maid the evening off for him to share a romantic dinner with Betty to rekindle their fading affection. The maids corroborated Daniel's account, but emphasized that their isolation in separate wings of the penthouse, wearing headphones, had rendered them oblivious to the unfolding turmoil. So they did not hear it. The maids did not hear it. So Ella praised Betty as a benevolent employer, but Dolly recounted incidents of hostility after being accused of theft of Betty's missing diamond ring, along with threats of termination. So Daniel further stated that he had admitted the affair to Betty, but had promised to terminate it. Daniel claimed that Betty flew in a rage, hurled in a chair at him, and retreated inebriated to her bedroom. So Daniel then withdrew to another room, where he was later jarred by a scream followed by a chilling thud. The postmortem on Betty revealed that marks on her body are consistent with the possibility of her being pushed over the balcony. Betty's friend, Jane, disclosed to the authorities that the Betty had informed her and she was going to ask Daniel for a divorce and was prepared to face Daniel's wrath. So in the course of the investigation, it was discovered that Daniel's sister, Delilah, had fallen to a death from 40th floor of Daniel's parents' condominium after an argument with Daniel. So such a long question, which is one of the favorite behavior. I think is common practice of our CLP examiners to do so. So how do you actually calm yourself? After reading this sentence in the course of investigation, you start to forget the first paragraph. It is common and it is normal, okay? Do not doubt yourself. You just need to be systematic. The correct approach that I have learned is in this way. You have to read the question first, followed by the scenario. That means to say you read what the question wants you to do, and then highlight the keywords. Okay. Secondly, try to identify whichever question that you read in your CLP paper, try to classify in evidence per se lah. Try to classify whether it is a criminal case or civil case. In this case, we do not have any doubt. This is a PP against Daniel. And what are the facts in issue or relevant facts? This is obviously about a murder. Okay, even though you don't know the section, also never mind. It's a murder. So, and you must zoom in to which topic. So usually, this sort of scenario question, they'll talk about relevancy. Relevancy in the sense that section 55 to 55. Do not just talk about 6, 7, 8, the one commonly used in the exam. Broaden a bit your mind, and be crystal clear about the parties and all the weaknesses involved. Because the name got so many. Suddenly Ayla, suddenly Betty, suddenly Dolly, and some more, one more, there's one Delilah, isn't it? So, and Jen some more. So please be clear with their relationship and what is their role, okay, for this question. Okay, so make sure you read the question over and over again before you actually answer or write in. Otherwise, you're screwed, man. I mean, seriously, you're screwed. Advise the prosecution on the relevancy and admissibility of the following facts with reference to Evidence Act 1950 and relevant case law. So these are the 4 things that you probably need to do. Okay, you are required to act for prosecution, and you are required to comment on the relevancy and admissibility, 2 different things of the following question based on your Evidence Act 1950. So this is how you apa nama? You answer, Okay, the first question. Daniel and Betty are married and live at Sky 4 condominium penthouse. Okay, whenever you see the word and, then, so, or etc. lah. My grammar also very poor. This is a compound question. Means, actually one question, there are two facts. First fact, Daniel and Betty are married. One fact actually here, satu fakta. Okay, so you be a bit, how to say, a bit sharp lah, like like an eagle, the bird. Okay, so to introduce the relationship Daniel and Betty. So under section 9 Evidence Act, okay, and both live at Sky 4. One fact here to say there is opportunity. Okay, Daniel are actually together with the victim. Okay, so you use section 7 of your Evidence Act to show there's an occasion, there's an opportunity for the accused. Then that means to say Daniel is other, because for a murder to take place cannot be natural death, isn't it? It must be the act of crime of someone, isn't it? Push Betty off from the balcony, and then she fell and then she died. There must be an act, and then both of them must stay together, isn't it? So this show under your section 7. And what is your conclusion? Very important, because you are going to decide on part of prosecution. So these evidence are relevant and admissible under section 136. Okay, so this is how you answer, even though this is a 2 marks. Don't just write section 9 and 7 then habis deh. So apa cerita kemudian? So must remember this and also what other question asked. Daniel's affairs with Linda. Okay, 2 marks again. If you want to go for easy way, motive of the murder, section 8, and famous case of PP against Sunny Ang. But somehow rather, if you want to, because there's no right and wrong answer in CLP one retrospectively, because in practice, there is also no right and wrong. It depends on your argument and your submission, what position you are standing. So if I am prosecution, I will use this also to explain the sour relationship of the couple. That means Daniel and Betty are not getting along well, because there are supportive evidence to say that, in fact, Daniel agreed to terminate the relationship. I believe failed to be done lah. Okay, so conclusion, evidence are relevant and admissible. So always mark down your conclusion. So Dolly's the maid narrative of Betty. It says that this year, I mean the language they use is a bit hi-fi. They use narrative instead of description. So Dolly recounted incidents of hostility after being accused of theft of Betty's missing diamond ring, along with threats of termination. So is it something to do with your facts and issue, or relevant, so-called the facts declared to be relevant or not? No. The hostility of Betty's, no, it's not about the murder. It's not about the defense raised by this Daniel as well. So you can submit this is not relevant and not admissible, so long you can debate. Okay, because you need to act for prosecution. Let's say I put you into a position whereby you act for defense. Would it be relevant? This Dolly's narrative of Betty? The answer will be yes, because here Daniel claimed that Betty angry, throw her chair, throw Daniel's chair, somehow or rather Daniel will raise provocation or self-defense. So if let's say you are acting for Daniel, I mean, of course, this is not the question one. I'm just extending the scope of discussion so you can understand a little bit more. So this evidence becomes relevant, You get me? This is how it play lah. But somehow or other, to answer this question, submit as a prosecutor. This is not relevant and not admissible because you are for that party already. And the loud voices, noises, lady scream, all that lah. Okay, so I put forward to you again on 13 January around 10, 11. This is how the question exactly as it is. Neighbors heard loud voices, etc. It show time and place. Okay, Section 9, Evidence Act, introduce when the murder and where the murder place and possible identity of the victim is a lady. Okay, you get me? Ladies loud voice ma. Okay, and a lady screaming noises from the penthouse. Okay, you must try to dissect the so-called facts one by one, because 6 mark you cannot just write, oh, is this relevant you just put once. Cause of the murder because of fight, probably there's some provocation happens, some intercussion happens between the accused and also the victim. So you have to use this one more step. You have to corroborate this piece of evidence with Daniel admission of that particular fight. So it showed to the examiner that, wow, you are really smart. This prosecution, I mean, DPP, sure win one. I mean, you know how to tally with the facts, with the questions that given to you. Okay? And then resounding part, again, section 7. But you cannot mix all this together, What I mean is you must be analytical. Okay, dissect the question one by one. So resounding thought is what? Section 7. Okay, effect. You cannot combine everything. Section 7. Definitely, if I'm your examiner, I will give you 1 mark only lah. Now you know the reason, eh? So, okay, so it showed to the effect. The body of the victim fell from the balcony of penthouse. So corroborated with one post-mortem report saying that the victim cause of death is actually jatuh mati. Okay, so how you apply is very important. This is how you uh, 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 shine your other peers lah. Okay, because you're acting for prosecution, you need to use whatever information provided in the question. Okay, so you submit at the end of the day. Yes, these neighbors, they did not hear ma. It's not the direct evidence. Sorry, did not see the murders took place ma. Correct. So these are all circumstantial evidence, indirect one lah. So you can infer there is a fight place, infer there's a body that fell and then died. So these are corroborative evidence, supportive evidence, which are relevant and admissible. Full stop. Okay. And we have subsequent question, I think, pertaining to hearsay and also this what we call similar fact evidence. We will discuss in the next class. Okay. And if you need any help,